Good day, Manic Monday. This is Christopher. Welcome to our webinar Monday. Today we will go over with workplace harassment. I will be co-hosted by one of my colleagues. But before that, I would like to introduce who I am. I'm Christopher. Christopher Waikoko, founder of Waiko Tax, an all-year-round, all-in-one tax payroll bookkeeping service solution. We have processed hundreds of thousands of PPP group, PPP funding, EIDL, and other grants for the past months. And that's why you guys are all here listening. And I know that as a business owner, we would like to learn more. That's why we're giving you some business topics that will help to grow your business. Now, if you would like to have a 30-minute free consultation about accounting, about your payroll, tax, bookkeeping, even PPP, please click the link or send us a private message so we could give you a 30-minute free consultation with one of our account managers. With that being said, let me introduce to you today our speaker. He's a lawyer. His name is no other than Mr. Attorney Eddie Garza. Eddie has been practicing law in the Rio Grande Valley of Texas for 25 years. He graduated with honors from the University of Texas at Brownsville with a BA in political science in 1993 and was the first graduate of this university to be accepted into the University of Texas School of Law at Austin, where he obtained his JD or Jurisprudence Doctorate in Law in 1996. He is a life member of the National Registry of Who's Who, published in 2001 edition, was also selected as a Texas Rising Star and Texas Super Lawyer by Texas Super Lawyers Magazine, and formerly named as a top young lawyer in Texas Monthly Magazine. Eddie is licensed to practice in all state courts in the state of Texas, federal court in the Southern District of Texas, in the United States Court of Appeals for the Fifth Circuit, and in the United States Supreme Court. He practices in the litigation areas of employment law, school district and junior college district litigation, educator liability, public official litigation, civil rights, government entity defense, municipal entity litigation, private passenger and commercial auto, trucking, insurance code claims, consumer law, personal injury, products liability, premises liability, and construction. Before I introduce, by the way, this is not legal advice. This is just for educational purposes only. Let us all welcome no other than Attorney Eddie Garza.
Good afternoon, Chris. How are you doing?
I'm good. How are you,
I'm doing
Eddie?
fantastic. Always great to spend some time with you today. Looking forward to sharing some info with you, and happy to reach out and answer some questions once we get kicking along.
Yes, by the way, the questions and answer, all you have to do, if you have questions, feel free to type on the comment section below. At the end of the presentation, we would be able to answer all your questions. I would read the questions. All you have to do is type it on the comment section. All right, so Attorney Eddie, take it away.
Fantastic. Let me just fire up the PowerPoint real quick here. Give me one sec. Okay. As Chris kind of mentioned today, our topic's going to be about workplace harassment. And, I found that in dealing in litigation over the years that I've been working, the people always have a general understanding or a basic idea of what workplace harassment is, but sometimes they get lost in some of the little details. So my point today is to share information that hopefully is valuable to you, either from the employer or employee perspective, on addressing issues with workplace harassment, how to avoid it, how to identify it, how to deal with it when it happens, what are some of the pitfalls affiliated with it. So that's kind of what I want to do. So I'm going to start off real quick by talking about some forms of harassment, just kind of in general. And you see some of the images that we chose there on the screen. You can see up in the right-hand corner where you have a physical touching, or you have other harassment type situations where maybe you have some office gossiping. And of course, you have other kinds of issues, just looking at the ramifications to what happens to the people that are subject to the harassment. But the point of it is harassment comes in many different forms. So most people, when they hear harassment, they're thinking of sexual harassment, and that's a very common publicized theme. And of course, that's one of them. But in addition, there's lots of other categories that sometimes employers may not be cognizant of, and it's important for them to recognize it. So let's get on and talk a little bit about some of the forms of harassment in general. Let's talk about sexual harassment. We've all heard of. This can come from anything from an unwelcome touching to an unwelcome comment to text messages, anything having to do with areas in the gauge of sexual harassment which make a person uncomfortable. Okay. Now, in addition, you have gender harassment. I'm talking about whether we're treating people disparately because they are male or female. And of course, you've got national origin, which is where the person is a country of origin, country of birth, such as maybe teasing somebody or making fun of them because of where they come from or what their background is. And by the way, before I go further, these categories that I'm putting up on the screen right now, these are actual recognized categories. They're under the law, under federal law and state law in Texas, of course. And so when we're talking about actionable harassment, these are some of the forms that they constitute the protected classes for harassment. So after national origin, we're looking at disability. And then, of course, we've got religion. And go back for. Okay, so we've got sexual harassment, gender harassment, national origin, disability, religion. Any one of these categories can trigger liability or responsibility on behalf of an employer if they don't handle the situations properly. Now, I'm going to go into a minute and explain what companies can do to help prevent and to help address these issues. But it's important first to understand what constitutes harassment in the first place. So a good rule of thumb is anything tackling on any one of these categories that causes another person to feel uncomfortable because of unwelcome conduct can fall under the category of harassment. So a lot of times you have to understand that harassment tends to come from the perception of the victim, perception of the person being harassed. So while somebody may be very sensitive to a gender joke or a gender comment, another person may not be so sensitive to it. So to one, it's harassment; to the other, it's not. There's a fine line between. It's not just an absolute black letter law written. So you have to take each case as they come about and realize that while some people may not be offended or may not be made uncomfortable, the typical type employee may so. So you want to protect yourself in those situations. So let's move on. Let's talk about some company policies, okay? In particular, conduct types. You got to understand when you're dealing with a company policy, and my firm spends time helping organizations write and revamp and address their policies to make sure they're in compliance with the law. But one of them is that the policy manual is a guide, okay? Policy manuals, in particular in Texas, they're not contracts. They're just a means of giving information to the employee and also setting forth for the employer what the parameters of harassment might involve. So, in the policy, you're usually going to see references to harassment in the form of verbal harassment, physical contact, jokes, graphics, photos, threats, improper requests. I've seen everything from, somebody put up a poster in the lunchroom and it actually had like, a picture like 5 monkeys on it. And they put the names of different employees on the heads of each of those monkeys. Well, to someone, that was just a common, funny little joke. But to one of those people who was named on that particular poster, they were offended. So they filed a harassment complaint. It had to be investigated. It had to be dealt with. How the company handled it after the fact was important. But more importantly, if the employees had recognized that verbal harassment, physical contact, graphics, and things like this can constitute harassment, then maybe they could have prevented that whole situation from coming down in the first place. Now, I'd like to show you a sample company policy because there's different kinds of provisions that you may run into as employers or as employees. But just to give you kind of maybe a generality of what's a proper reporting policy, it looks something like this, okay? Company volunteers as well as company employees responsible for keeping the work environment free of sexual harassment, of all such harassment, excuse me. If you believe that you've been harassed or have become aware of an incident of harassment, whether by an employee or a non-employee, you should report it as soon as possible. Before I go any further, you're going to see pretty commonly, if you don't have one of these policies in your workplace, that reporting is probably the primary issue and the primary pitfall that happens when we're dealing with situations involving harassment. So the companies, an intelligence company, is going to put that in their policy so they can have something that makes their employees aware of the fact that they have an obligation to report this stuff. So in this example here, it says report as soon as possible to your supervisor or to your office manager. Do not allow inappropriate situation to continue by not reporting it, regardless of who is creating that situation. Now, the important protection here for employers is that the employer has now made known to its employees in writing, and it can always refer back and know exactly what a policy looks like, in saying that it is taking an active role in wanting to address and prevent harassment, but it can only prevent and correct what it knows about. So the employees have obligations to be able to report it. And the policy, this one in particular, this sample, it spells out specifically who to tell, why you should tell, and how important it is to tell. Okay, those are three things that if in a company policy we're talking about reporting is very significant, because the worst thing you want is saying, I'm going to report it, but I don't know who to report it to. And if you report it to your supervisor and the supervisor is the person who's doing the harassment, where should you go? Well, your policy should reflect that. Go to the office manager, go to the owner, etc. So that's the reporting part of it. Now let's talk about privacy concerns, okay? Another thing that sample policy should have in place is issues protecting the privacy of those making complaints. So this sample, for example, says in response to every complaint, the company will take prompt investigatory actions and corrective and preventative actions where necessary. All employees should be aware that the privacy of the charging party and the person accused will be protected to the extent consistent and effective enforcement of the policy. Company retain confidential documentation of all allegations and investigations. Now, why is this important? Okay, the reason the primary reason this is important is because one of the things that we found, and it's common in many cases throughout the country, when people don't report harassment, it's usually because they're afraid to get ousted. They're afraid to be retaliated against. They don't want to be identified. They wouldn't mind saying something if they knew it wasn't going to come necessarily back to them and cause harassment to occur in their regard. So when an employee witnesses something, and we want to encourage them to be able to report it. So in order to do that, we got to protect their privacy rights. So these policies are designed to, a sample policy like this, for example, should have provisions in it that are indicating to the employee that everything you say is going to be kept in the strictest of confidence, so that it encourages them to come forward and share and explain without having to worry about any kind of retribution or retaliation after that. Now, let's talk about some reporting responsibilities, okay? Reporting leads to protecting employees who believe they've been harassed. That obviously one of the primary indications of why you need to do this. But you got to think, if you're the employer, and I'm speaking to employers, and I'm assuming there's some employees also that could benefit from this as well. But if we're looking at it, the reporting aspect of this is designed so that the company can take a position and take a stance to show that it is trying to protect and defend its employees. Okay. Next, how do we do that? Well, report it immediately. And this means anything's reported. Sometimes the report's going to come from a victim. Sometimes it's going to come from a secondhand witness. Sometimes it's going to come from somebody who only suspects the harassment is coming. So just because two individuals, maybe they don't necessarily feel harassed, if an employee witnessed something that he believes or she believes is harassment, they should report it. The second obligation they have to do in reporting is you got to cooperate with the investigation. So for employees of the company, when they are following an actual plan that the company's put together, there's going to usually be some interviews. Maybe they do some written statements. Well, it is the employee's obligation to cooperate with that investigation. And that employee can be subject to discipline for not cooperating if it's something that the employer has in its policies and procedures to take place. For the employee who's reporting, they should be encouraged to work normally, but be mindful of the fact that you're investigation. So don't share that information with other people. Don't, keep any documents and things you have, somewhere where no one else can identify them or see them. And of course, number 4, keep everything confidential. Whenever you're dealing with the person who's reporting harassment, they may not be interested in confidentiality, but the employer is. So that employee needs to be cautioned consistently that anything having to do with these investigations is confidential. A lot of times these harassment situations can be pretty sensitive, somewhat embarrassing for the employee or the victim who is making a report, or sometimes it's embarrassing for the company in that regard. So keeping things confidential and private, I cannot stress enough, is very, very, very necessary and important to do. Okay, so now let's talk about what can possibly go wrong, okay? Now, a lot of times people assume that the employer is always liable for situations of sexual harassment. It's not entirely true. The employer can get into trouble when the employer is made known and has awareness of something that's happening and doesn't take appropriate action to remedy it or correct it. But I want to talk for a second about what happens to the employees, the personal liability that can affect employees in that regard, because a lot of people overlook this. This is what encourages employees to make sure that they cooperate and to make sure that they also are not creating an environment of harassment. So let's see what happens. Okay. So as an employee, one thing that the employee can be sued for, I'm talking about an employee who's actually accused of harassing another. Okay. It's not just about losing your job. That employee could be personally liable for intentional infliction of emotional distress. That's a common law cause of action, can be filed by anybody in the state against anybody else, as long as they can establish and prove that they're deliberately trying to cause emotional distress on someone. Second thing that can happen, you saw that example at the beginning of my first slide where you had like a touching on the shoulder. Well, that's battery, that's assault. Okay, you can be sued civilly for that. That's not just a criminal cause of action, but there's actual civil causes of action. You can sue for money damages if somebody assaults you or causes a battery or unwelcome touching. Of course, from the employee perspective, you've got everything from suspension to termination for the improper conduct finding. All right, not necessarily for an allegation, but for a finding. Now, if someone is accused of some type of improper harassment, and while they're being investigated, the company determines that it'd be best to separate them away from the situation. In those situations, the employee should always be suspended with pay while the investigation takes place. After the investigation is concluded, if there's a finding, you can terminate. If there's not, they come back to work. The reason you do it with pay, this is a little nugget for everybody out there, all the employers. The reason you do it with pay is under the law, if a person is suspended with pay, that is not considered adverse action. It's not considered a harmful act because they are being suspended, but they're not losing the monetary benefit of it. If you suspend without pay, even during an investigation, you've actually taken a step of a decision-making process, and you've potentially affected that employee and given them a possible cause of action against the employer. So, of course, you have suspension or termination for violating the reporting policy too. Employees can get in trouble if it's determined that they knew something and just absolutely failed to report it, failed to cooperate in compliance with your policies. So if you have a policy of reporting, an employee just decides, well, I wasn't going to say anything because I didn't feel it was my place, they can be disciplined as well. And of course, it's important, at least in Texas, to know that just about every employee in Texas, absent maybe teachers and certain exceptions, are at-will employees. They have no contract of employment. That means the employer can separate employment with that person for any reason as long as it's not a discriminatory one. And violating policies affiliated with harassment or participating in harassing conduct is certainly the type of thing that an at-will employee could be terminated for on the spot. Doesn't even take much effort to do that. Now, personal liability never really affects people till it affects their bottom line, right? So in these situations, the employee needs to understand that if they are sued for some of these reasons, because maybe they're not complying or they are the actual harasser, there's usually tremendous expense in defending against litigation. I defend these types of causes of action on behalf of employers all the time. And, the rates that lawyers can charge per hour, the hourly basis, could be somewhat pretty intimidating for the average person out there who's just trying to personally protect themselves. So they're talking about lawyers' time, you're talking about filing fees, you're talking about court costs and that's expense, the expense and exposure if a judgment's rendered. Secondly, in situations where an employee is verifiably fired for misconduct, there's no unemployment benefits. That can be challenged in Texas, and the employer can actually provide evidence that they had an absolute justifiable reason for terminating the employee. So now they've lost their job. They have no option for unemployment. They're potentially being sued. They're potentially having to pay just for the cost of litigation, and they're exposed to a possible judgment. So this is the kind of thing that employees should really, employers would help in advising them ahead of time, saying, look, there's a really good reason why you shouldn't harass people at the workplace. And there's also a really good reason why you should cooperate in investigations. Of course, the end result of anybody who gets sued, there's a judgment or damages levied against that person personally. The company wouldn't bear those expenses or bear that cost. That's an issue for the employee. Now, if the employer has determined that the employee is being wrongfully accused and has done everything properly and decides, that he's only being sued because he's doing something in the course and scope of his employment, in that situation, there are circumstances where the employer could step up and defend the employee, but those are on a case-by-case basis as well. All right, almost wrapping up here, but the company obligation, okay? We've talked a little bit about the employee and what happens for them, but just to sum up what the company's obligation is, Employers are to exercise reasonable care to prevent and correct promptly any harassing behavior. So the essential obligation of that company is once it is made known, once somebody in a supervisory position is made known of a harassment situation, it's their obligation, the company, to take action. Okay. In particular, they take action to not only to prevent but also to correct. So that's when they have to address. Now, there's all kinds of different avenues for that. There's, usually if a harassment situation has been identified and it's maybe leaning towards, yes, there's something uncomfortable happening, but it's really not like terminable conduct kind of stuff. In that situation, which what is traditionally done is the person who's been accused of harassment is moved in a situation where they're not encountering that particular employee, so that circumstance, those interactions are no longer happening. That usually satisfies the standard under the law for the employer to take action. They don't just have to fire everybody who's accused of harassment. That wouldn't be a proper way to run business in life. You have to go through a certain investigation and make some findings. So there's reassignment, there's changing scheduling of hours, there's maybe having a counseling session between the two and making sure that the person who had felt harassed is satisfied with whatever resolution the company has made if there's no particular movement or no suspension. And then, of course, the more extreme remedies, suspension or termination or things of this nature. So hopefully at this point, you've kind of grasped an overall understanding in general. This is kind of a bird's eye view to harassment in the workplace. But what I think to identify just a couple things that maybe most employers don't really grab a handle on is if you take anything away from this conversation, if you're an employer, it's one, take action and react whenever you're made known or made aware of any kind of harassment. Take all forms of harassment seriously, be it sexual harassment, gender, religion, national origin, even if it doesn't fall into one of the categories that I identified. Best to fall under the side of, well, you know what, I'm going to investigate it and treat it like a harassment complaint, because it creates a very good work environment and the employees tend to be a little more open about it. And for the most part, they're going to be more understanding when the company is determining how to handle it forward. If you don't have policies in place or procedures in place, I would recommend that you have some type of harassment policy, maybe similar to the language that I shared earlier, so that every employee in the company is made aware of what's expected and what the obligations are. All right. So with that, I am now open to any questions anybody might have on this topic or anything affiliated with it. I'd be happy to give my best attempt at sharing information, response, and answering your questions.
There you go. Thank you very much, Attorney Eddie. I've learned a lot. Being an employer, we have more than 10 employees already. This is very valuable in able to protect the interests of both parties. When my first question would be, even in the process of interview or selection, can the employer already be liable for harassment, even they did not hire yet the employee or potential employees?
Okay. So if the real kicker, right, is if the employer has been made aware of a situation under their control, in other words, they have authority to take action, and they haven't done so, then there's the potential for liability. If they're in an interviewing process and
Mm-hmm.
someone comes in and just feels maybe that the interviewer was being a little harassing with their questions to that extent, a non-employee could make a harassment claim. It'd probably be more of an individual complaint against the supervisor because there is no employer relationship.
Mm-hmm.
But if they do believe that that person has not been hired because they failed to comply with the harassment, now you got a whole different cause of action in there. So it opens up a different kind of
Okay.
discriminatory claim. So very, very
Oh,
careful. You
yes.
want to make sure you know who you're interviewing.
Mhm. Yeah, that's true. How about for people that are already employees, then they were asked by supervisor. I know this is very common, especially to work on holidays, weekends, any type of that they're supposed to be off, and they're being asked repetitively to work. Is that going to fall as harassment?
Great question. Great question.
Mm-hmm.
You know, the only employer that really is, I guess you'd say, maybe obligated to give some of those federal holidays off are the federal employers. Okay, like the post office or the federal
Mm-hmm.
courthouse. Every other employer, like myself, I'm a private employer, I have a law firm here. If I don't want to give any days off, I don't have to. If I don't want to give vacation benefits to my client, I don't have to do that either. There's no legal requirement for me to do so. But if the employees are hourly, then of course you can't work them beyond 40 hours without paying overtime. There's certain wage and hour laws in effect. So when you're talking about days off or holidays, things like that, if they are applying a rule to a certain class of people and not to another class of people, for example, for some reason, all the women are working the holidays and the men aren't, you know, and just consistently you can get a pattern like this. And yes, they can say, look, I'm feeling like I'm being discriminated against really
Yeah.
predominantly, but maybe also being harassed a little bit because I wasn't playing the game right. And I got stuck working on the holiday and they didn't, you know. I didn't comply. I didn't go out and have drinks with the manager. So because of that, I have to work on the weekend. He doesn't. In those situations, that can lead to a harassment complaint as well. But we're teetering along the line of the Labor Code, Title VII in
Yes.
discriminatory claims. Yeah.
Yes, would be if there are no action were taken by the employer, can the employer be part of the lawsuit, either being accomplice or accessory?
100%. Actually, the lawyer would be the employer would be the primary target. When you have a harassment situation that occurs at work, okay, and say it wasn't caused by the employer at all, it was just an employee who was totally harassing a man, a woman, or a woman to man, whoever it may be, and it gets reported, and the employer's response is, you know what, boys will be boys, or employees
Yes.
will be boys. It just happens like that. They let it go, and they don't do anything about it. Well, now the employee who's been harassed, has reported it, is feeling horrible. Maybe they're sick to their stomach. Maybe they have to miss work. Maybe they're not feeling comfortable. They have a cause of action against the employer for not taking action. Yeah.
Okay. One of the discussions you cover here is even non-employee. It says here if the person that's harassing the employee is non-employee, who do we categorize as non-employee? Like customers harassing the employees?
Right, right. If you have a restaurant, for example, and within the restaurant you have tables, and at one table there's customers, another table is another customer, and one customer is harassing the other one, there's no real civil cause of action to sue the company because of a horrible event that's happening there. He has no control over that guest other than to remove that guest from the premises. Okay. Now, if the employer is made known to the situation and totally condones the situation and maybe encourages the situation, then you can go forward. Maybe those cause of action I told you about common law, like intentional infliction of emotional distress, or one of
Yes.
those alters. So it may not be a harassment claim, but when you've got, okay, here's a rule of thumb, Chris. This is real important to understand. Angry people go to lawyers. Okay, upset people go to lawyers. They go out when someone gets fired. If they're angry about it, they run to a lawyer. They try to find a means or method of retribution and coming back. But when those same people are not so angry because they've been respected, they've been dealt with properly, they've been handled, they know the employer's done everything he or she could do, they knew they were understanding about it, they're less likely to file a claim in the first place. And that protects the employer just the same.
Okay, yeah, because there was instance, but this is just one very few. We have a customer that become harassing our receptionist because he was trying to get hold of the account manager, but of course it is already weekend, and he's cursing towards the employee. He's also being racist by telling them you don't understand English because you are all Mexican, like that. And that was we have to let go of the client, and we emailed him that we no longer going to work on any of his taxes because of that derogatory remarks, that we protect the emotional wellness of every employees, and
Awesome.
nobody is allowed to really treat everybody like that. Is that the right way to do? Did we do this right of way of action?
100%. See, in that scenario there, your employee understands and knows that the company has her back, okay, or the company has his back. You're on my side. You're not going to
Mm-hmm.
allow these types of situations. And and no company. I mean, you're a business owner. Nobody likes to lose clients, and nobody likes to lose revenue. That's how we pay our
Yes.
bills. But there's
Mm-hmm.
also you want to hold your head up high. and you want to have that good rapport with your existing clients and with your company, because that's going to carry the business forward long term. So that was a very good long term thinking, and that's exactly what I would have recommended you do.
Yes, actually, before we even go, we did a further investigation on the management about the email, even the conversation, everything has been written down. But at the end, we tried to be that on top of our customer service. But if those are already been verbally expressed and also written through email, then we have to disengage with the client. That's why we are the best of our customer service. We're trying to do it, but we have to find balance somewhere.
Yeah, we all want clients. We don't want them that bad. We
Yes,
don't,
and
we don't
then
really need that.
yeah, that's another question. Would there any statute of limitation? For example, the client or the employee already resigned after 1 year. Can he go back and file? Hey, you know what? I felt like I was harassed.
Okay, that's a two-ended question. Number one, the typical
Mhm.
statute of limitations is 2 years. However, when you're dealing with if you're talking about a discrimination type complaint, like saying that I felt like I was, like they're actually fired, let go, and I was fired because of my gender, I was fired because of my race, something to that effect, right? If it's just like a termination type claim, they actually have to initiate some administrative procedures with the EEOC or the Texas Workforce Commission, and they
Mhm.
have deadlines to do that. There's a 180-day deadline to do it with the state, or a 300-day deadline to do it with the federal equivalent. If they don't do that, that's waived, and they can't go forward and file a suit within those 2 years. They're barred. If they jump through those hoops, they're solid. Now, on a typical harassment, like just a regular, I've just been, sexually harassed at work.
Mhm.
I believe you're going to fall under a typical 2 year statute of limitations. But if I was advising a claimant who was going to file suit, I would tell them they have 180 days to go file something with the state, so that they can do their own state investigation and then give you a right to sue letter. So, but that'd be
Wow.
definitely not over
Mhm.
2 years.
Yes. If this is happening or this happened to an employer, is there any specific his insurance can cover it?
Yeah, most insurance policies, if they're going to have an E&O coverage policy,
Mhm.
right, errors and omissions, or a commercial liability policy. Now, what happens with a lot of employers is they go and they get a policy for their building, for example, and they don't realize
Yes.
what they buy a commercial policy, but they don't realize it doesn't have a provision that will protect them in commercial liability situations. So when they're talking to their insurance agent, it's important for them to say, I want to make sure there's a provision in here, or I have a policy in place to cover me in employment, workplace related employer employee claims. Okay, those
Mhm.
are very specific. They don't come in every policy. So if you don't ask for it, you may not get it. So if you're going to a local agent or whatever, and you're talking about insuring your company, you want one that will cover employers for employment type situations. Once you have one of those, typically they tend to do that. Sometimes they get involved at the investigation stage. Other times they only get involved when a lawsuit has been filed. It's always best, if you feel that there's a significant claim happening or there's something really serious, get them involved. You call up your carrier and let them know in advance. They may want to take a proactive approach and
Mhm.
assign a lawyer to help investigate.
Right. What about if for example, like in an office where there are regular contractors who are checking the air condition, the roof, and then the maintenance of the building, if they are the one, if they are the abuser or they're the one harassing the receptionist or the employee, would the company as an employer also be responsible for that?
I think the employer of the contractor. In other
Mm-hmm.
words, let's say I'm contracting an air conditioning company to come do some work here, and their air conditioning rep is harassing my employee. My employee may have a cause of action against the air conditioning company
Mm-hmm.
for because they're responsible for the acts of that particular employee and what he's doing. To me, he's an independent contractor. To
Mm-hmm.
the AC company, it's an employee. So in that regard, they owe different duties to that guy than I owe to the contractor. The only reason I could be responsible as an employer for the contractor's work, if I'm exercising total control over the contractor's duties and tools and services. Usually we
Mm-hmm.
don't do that in those situations. So that
Okay.
you still want to respect the complaint, but I think that's where the employer's duty at that point is to call the AC company and say, don't send this guy back here anymore. Handle the situation to our satisfaction, because this guy's harassing my employee.
Yes, we still have, as a customer, we still have the right to diffuse and then to refuse the service to this contractor, just to protect, especially if there's already an uncomfortable condition or situation that happened.
Sure.
Well, there you go. And now we will proceed to any. Where can they find you if they want to contact you, Attorney Eddie?
Okay, easiest place. I got a modest website called it's www.esparzagarza.com, just like it
Mm-hmm.
sounds,
Yes.
esparzagarza.com. That's our website. In there, you've got contact links for email, phone
Mm-hmm.
number, address, anything you need like that. So that'd be the first place.
Yes. That's why I posted also your contact information, your contact link on LinkedIn.
Awesome. Yeah,
They
for
can
sure.
also find you there. All right, guys, I hope we learned something today. If you have further questions, we will have a replay of this presentation on our YouTube channel. Just follow Wyco Tax. But for any EIDL questions, please click our free consultation form. We attach our link here at wycotax.com, because we just like to bring you the best and any best speakers and any relevant matters about your business. Again, if you would like to save a 10,000 tax saving strategies, we are also doing that consultation and strategy prior to tax season, because we are not just your preparer, but we are your planner to make the most out of it. Again, Attorney Eddie, thank you very much for staying with me.
My
In
pleasure.
less than 40 minutes, we were able to give them. I hope it adds value to everyone. And again, if guys, if you like this, please share and subscribe on our YouTube channel, because here in Wyco Tax, you guys deserve the max. Thank you very much. Thank you, Attorney Eddie.
Have a great evening, Chris. Thank you.
Bye.
Bye
Mm.
bye.